25 is a matrimonial dispute, my lord. Where, my lord, the divorce is decreed by the municipal
You're praying for upgradation.
upgradation at 2, my lord. Because, my lord, is not,
Say at 2 or what? We'll try.
my lord,
That
it is,
only I
it
can-
is not disposed on merit, my lord. It is only on jurisdictional point, my lord.
Whatever.
The decree is set aside, my lord.
I have marked it.
Yes, my
And
lord.
so it will be up at 2.
And my lord, the matter is covered by a
We are
judgment.
trying.
Yes,
We'll try to hear the matter.
at 2, my obliged.
Not at 2, well, saying the thing.
My lord.
We'll try to hear.
May it please your lordship. Lordship, I beg to mention item number 12, your lordship. In this matter, I am appearing for respondent number 128, your lordship. In this case, we have filed an IA, lordship, but the same is not on record.
It's a MEC.
Item number 12. To take my permission, isn't it? No, it is Jani, so but you should inform me, isn't it? Okay, lordship. Let it be after 4 weeks, lordship.
After Bihu, your lordship.
After?
Bihu vacation.
4 weeks, lordship. January is full of holiday.
Your lordship may fix a date, your lordship.
12th of February.
Deeply obliged.
On the prayer of respondent,
Yes,
lordship.
yes.
My lord, I beg to
Dependent
mention item
judgment.
13, my lord.
Pardon?
And it is
Item
matter
number?
may be passed over and after Bihu, my lord. 13,
Item number 13.
with due consent.
The other
Consent has
side
been
is appear you are appearing.
consent has been taken, my lord. For tele-
Union of India is there.
Yes, ma'am.
With consent of the other side and the conflict of interest it by next. After Bihu,
After Bihu, my lord.
it will
February.
be accordingly listed.
February 12.
February 6th of February.
Deeply obliged, my lord.
May I please,
Lordship.
your lordship? I'm mentioning for item number 23. And for respondent number 4, kindly adjourn the matter. I have taken the consent of the other side.
23.
Yes, your lordship. After beautification.
You are for the respondent?
Respondent number 4.
Consent of the other on respondent. After Bihu, it will be accordingly listed. After Bihu, as listed.
Deeply obliged.
Lordship, item number 10, Lordship. Lordship, Land Council of the case could not appear today. Kindly pass over the matter for the day.
Who is the council? You
My
and-
S. Ahmed, his father-in-law passes away last night.
Achha.
Kindly pass over after Bihu.
Yes, I mean, after Bihu. Oh, after Bihu
Okay.
vacation, realistic.
Petition.
The present petition is allowed and the order passed by the learned Muthu number 1, named music case number 71 of the 2020 of TS 17 of the 2017 is hereby set aside and quashed, and the petitioner is allowed to withdraw the suit till liberty to file afresh on the same subject matter, considering that the non-gender and the gender parties as well as the non-identification of the suit properties may be considered as a formal defect.
Much
And these two ground only we have error.
my lord.
Tick.
My lord, this case, your lordship has rejected earlier, my lord.
Now, can you tell us what is the stage of the case? Because I can still remember while
Yes.
rejecting the earlier prayer, There was an observation that two, three, some vital witnesses are there.
Not directed to examine 5 witnesses, 5 things.
Yes.
Already 4 months.
Ah.
Out of the listed witnesses, my learned submitted 5 names.
Ah.
But he examined only 2. And he examined further some more witnesses which were not given before your law.
Some of the official witnesses have been.
Some of the other witnesses. How given before your law.
Ah.
Only 2% have been examined. And for last 2 months, there is not a reflection.
Okay, we are at this stage, we are calling for the
Yes,
scan copy of the TCR. Let the immediately after vacation, we are fixing a date here.
Your Lordship,
Yes.
Your Lordship, the special PP, Mr. Javed Ali Hassan, will be appearing in this matter. He hasn't been furnished with a copy, Your Lordship.
That is the problem, my lord. I don't understand because the PP is representative of the state. We assert him because he has no. We start the PP, my lord, public.
But I think that
There is a
Mr. Hassan
notification.
is appearing here.
Yes, that is true, my lord. But I know because my lord, I know that Mr. Hassan is there. No
But
doubt,
otherwise PP is here.
yes, yes. But other people will not know, my lord, because it is not possible for each and everyone. I even my clerk to submit for me. In fact, he should have submitted my window. I informed him yesterday that
Just supply copy
my lord,
because he is appearing. I know he
Yes,
is
yes,
appearing.
yes,
Yeah.
I have in fact the copies before the my lord, which that is submitted.
Handed over the file.
Okay then. Because he is appearing. Most probably in the planet trial court below also he is appearing.
Yes,
So he is presently appearing before this court.
Not,
So you can otherwise.
we can hand it over through our office.
Sure, sure. Okay. We are not reflecting anyone. You just supply to the copy.
Yes.
And we are fixing for the TCR
Yes.
when 22nd of January, immediately after,
Yes, Your Lordship.
so that we can finish.
This is okay for the moment never appeared. And your occasion also my lord, this are copy notice, but he never appeared. So if your lordship-
appointed.
Yes, your lordship has
No,
Your
no, this is
Lordship,
the
at
first case. I
stage-
don't know whether it was appointed or not.
I
Earlier,
was
but
appointed.
earlier it was appointed, I think.
Yes, my lord. Earlier- Okay,
Because see now, POXO is also here, na?
yes, that's right.
So that is why. So if we have to issue notice in that case to 22nd January, I don't know whether it will be possible or not. No, yes.
Yes.
No, whether it will be possible.
I'll start the
We'll try it, okay, then, because now the only 1 day left. After the holiday will start,
No, I-
so 22nd January may not be possible, I think. To take a date at least 29, 30 January, I think, na? That will be proper, I think, yeah. 30 month period,
because my lord, the we had for 4 years.
yes.
My lord, he
I
never
can still remember the
even
case.
though submitted, my lord, even though this notice is served, you never appeared.
Heard Mr. J. Payne, they done heard. A. Brown, you're appearing on behalf of, no, we
Yeah.
record whose name, your name?
The special PP will be appearing, Your Lordship. Only his name can be reflected.
No, today you are appearing here?
Yeah, definitely.
Okay.
So I'm going to hand over the file
Okay.
through office, Lordship.
Hard MS SH Bora, the learned defense. However, it is submitted by her that the case is the special PP, Mr. M. Hassan is appearing, and Hassan Noji Hassan is appearing in this case, and accordingly she submitted that she will hand over the copy of the petition to him through his office, to her office. Also issue notice to the informant respondent number 2 through through OC of the concerned police station, routed to the office of the registry and the public secretary. Petitioner will take steps immediately and also call for the scan copy of the PCM. Let the matter be accordingly listed on 30th of January. Okay, we
Lordship, in the meantime, my learned friend's name will be recorded on behalf of the special PP. He's also appearing.
MK Brown appeared.
Your Lordship, may I pray that Mr. Hassan's name be reflected in the cause list? The next.
registry thereby also hereby directed to reflect the name list. Assign the special PP and above list. Next data list.
Obliged.
Nothing. Directly assets of motion and right. Yes. From Udalguri.
Danpuri to Pak.
Hmm.
There is a phenomenon from 13 10 3. Water and pump. Water is what is part is disabled. So we need all along staying there in my matrimonial. Still I am staying there. And friend is staying at Sir. I never stayed in Sir. Here I able to down full. Now um, keeping a disabled daughter. And she somehow I am staying is to
So what is the stage of that case now?
visit.
Service report. So at this stage, you need any other prayer? Any other interim prayer is there?
My Lord.
But at this stage of service report, why you need any interim prayer? Let her appear once.
Both they are
No, you may appear once. I'm saying. You can appear once. In the meantime, we may dispose of the matter. Just I'm saying because it is a service report only. So service report means once you can appear and then thereafter you will file WS and all. In the meantime, matter may be disposed of here because it is a transfer petition only.
but hearing
No. I'm not on that. We are not going to dispose of the matter. We are
Oh,
saying that at
yes,
this stage, stay may
yes,
not be
yes.
so much essential. That's what I'm saying.
Yes,
Yeah.
yes.
Apartments located in an- It's an application with CPC praying for transfer of TS vector T case number 34 of 2025 from the court of District Lalgudi Court and this test. So issue notice to the respondent on speed post and process. Let the matter be according to state. You know what which is the next date fixed there? No. What my intention is that we may fix it prior to their that fixed by the court. That's why if you don't know the date, then we can just okay. No issue. Please don't switch. Yeah, time in this all of
number 3.
an order to work with that date to back. Yes, Mr. Mamu.
My lord, kindly see the impugn order page 16.
No, just tell us the respond number 1, 2, and 4. Do you have any instructions now?
Lordship, we received it last night, Lordship. We would like to file an affidavit, Lordship, to keep it on record, Lordship. We have
No,
the
The
instructions,
instruction you
Lordship.
have received
Yes,
on the last
Lordship.
night.
Yes, Lordship. We could not file the affidavit as it was too late to file the affidavit, Lordship. It needs to be
Sir.
sworn in, Lordship.
In effect, affidavit. Kindly hear me that how illegalities have been done by the IS against us.
It's okay. Now hearing is may not be so material because the question is they let them file their affidavit. And how many weeks you need after immediately
Lordship,
after Bihu?
Right after Bihu, Lordship.
Right after Bihu.
Lordship.
This is a matter regarding an school. PR Milan High School at Bukuatepa. So the land of the school is situated at Bukuatepa. All admit cards and mark sheets are also in the name of Bukuatepa. All in a sudden, the Bukuatepa name was deleted from the signboard. So it is an arbitrary decision. Because
So what the instruction they have, they
Lordship,
file the affidavit, then only
kindly
will come to
should
know.
be kindly.
She's also saying that
So that we
immediately
have
after
a good case.
heard Mr. M.M. Mahmood. Now you are for the secondary
yes,
education.
Lordship. For respondents 1, 2, and 4, Lordship.
1, 2, and 4. And who is 3?
Lordship 3, Mr. B. Chaudhary appears for SSC, Lordship. Mr.
He was appearing, na?
Yes, Lordship.
But anyway, heard Mr. M.M. Mahmood, the learned counsel for the petition. Also heard M.S.R. Borua, the learned counsel appearing for the learned standing council secondary education for the respondent number 1, 2, and 4. And accordingly, she submitted that they have already obtained the instructions from the authority concerned on the last night, and hence she requires some more time to file their affidavit. Prayer allowed, let the matter be accordingly listed as this very prayer. Nice. 22nd
Lordship.
Second,
of January.
one.
January. Yeah. Do one and so enabling the respondent side to file their affidavit. Okay, deeply obliged.
Hey.
Yes.
Second, whereby my reason for filing is and it was only nice. But this time my lord, something saying the petitioner number 1, the respondent number 1, and they have inherited one their mother land 8 of now the petitioner, the respondent 1 explained his interest to right better interest over that inherited property.
Respondent 1.
Yes, respondent 1. He filed a suit pilot to giving right better interest over the inherited property. So inherited property means I am also one of the co-owners. Now what happened, my lord? The lordship will come is 66. Page 66. The suit was filed by the respondent 1, my lord, and someone was issued to me, my lord. Page 66, the order, first order. Where it is stated, my lord, that summons were duly served on 7/8. 7/8 was the date when summons was. Now on that day, my lord, the case counsel, my lord, had filed a petition in time. Now, my lord, the lord will see next page 67, my lord. Order dated 22/10, my lord. Here, my lord, what happened, my lord? Then the presiding officer, my lord, was out of state on leave. But defendant and counsel also, my lord, due to his illness, he also remained, my lord, on consecutive days, 10 and 6. Date was fixed by the order was passed by Secretary. 16, my lord, 10/11. Now, your lordship, I will come to the medical ground, my lord. For that impugn order, your lordship. Yes, 68. 68, the impugn order. The petition number so filed by the defendant, seeking another date for filing written statement going forth. Or use the case record, it reveals that the summons were served against the defendant on 11 page. Say is the 91. The discretionary method, directory. Says that 91 days from the date of service of summons. Thus, it appears that the statutory clear request over. Therefore, the defendants are rejected. According the suit will proceed expertly against the defendant. However, they are at liberty to take part in the hearing as per law. The next jurisdiction 71 review matter for filing expert case. Now, this was taken up on 91 days. The date was fixed on 91. The court has fixed the date on 91, not on 19.
So where is your petition filed on 10/11?
Yes, that petition next is 69. That engaged counsel, he also remained absent. That 69 was stated that for unavoidable domestic affairs, then could not file it.
So it's very casually you have filed the petition
What
without
happened,
any
my lord?
ground.
Yes. Thing is that, my lord, I have connected the medical.
No medical report now you are annexing, but the petition is a very,
Yes, my lord.
very casual manner you have filed the petition.
Para 4 may I take it off? Just for women, para 4, I have, I have extended phase 6. Thing is that, my lord, phase 6, my lord. The petitioner submits that, petitioner submits that they have no knowledge regarding the absence of their engaged counsel on both the date 20 and 25 and 7:25 without any step. It is absolutely personal. However, on obtaining the certified copy of injunction order, there is an injunction order, then only we can know. I have annexed that injunction. So an advocate on 7/11/25,
Which para you are reading?
paragraph 4, my lord. Page number 6. Very. The petitioner submits that they have no knowledge regarding the absence of their engaged counsel on both the dates 22/10 and 6/11 without any step. The same is absolutely personal to the engaged counsel. However, on obtaining the certified copy of the injunction order on advocate on 7/11, the petitioner number 2 applies the petitioner number 1 regarding the present situation. While the petitioner number 1 is an aged person of 5 years and physically remain blind, unless he was without vision, my lord. Petitioner number 1, he has lost both his vision. And the counsel who had engaged, he is also able person, he remain absent on without it. And he, because of his vision, he cannot find physically remain blind until a surgery was conducted on 27/11/25 at Chandra Prabha Hospital at Surat to remove mature cataract from both the eyes. I have annexed the document. Further, was defendant number 2 on the advice of defendant number 1 applied for the certified copy on 12/11 of the order passed in title to number 71. The date of making over the copy of the defendant was on 11. According to the petitioner, without waste of any time, approach the Honorable High Court of filing. Now, paragraph 5 is regarding the access. My lord, my available right is gone, my lord. I will not be able to find my evidence. So the land belongs to both the plaintiff and the petitioner. I have annexed the pata where they have started their date. I have also annexed the Domamunti where my names are there. So considering, my lord, that the provision is, my lord, direct, my lord, only 91 days, only 1 day, the council has made a mistake and I was totally blind. So don't you see my document, medical document, page 7. And are page 7. There is the operation certificate of yeah. Raman. Other you are conduct 7/11 and diagnosis both eyes. So genuinely, I was just I dependent upon. Yes. So only one day, my lord, your lordship is allowed, and my lord will file it on next day. Put there.
Administrative people, the learned counsel. This is an article. The order of 10, 11, Mississippi Church Senate, your in PS case number 71, the prayer of the defendants filing written statement in the suit and fix the case for expiry against it. But submission is that the present petition number and the are the brothers and they are the they have the right the interest over the suit. However, the respondent number one filed a suit being numbered as TS 71 of 2025, seeking right title and interest for this. So, the suit property jointly belong to the also to the respondent number one, so being the brothers. The after receipt of the notice, some the count and this counsel for the petitioners appeared on their behalf and filed an application seeking time for filing their WS and by order dated 21/8, the prayer was also allowed with an observation that defendant the summons were duly served on the defendant petitioners on 11/8. However, on the next two consecutive dates, the defendants of the petitioner remain unrepresented. They remain unrepresented, and the learned court below was the learned presiding officer was also on leave these two consecutive days. However, the petitioners were not aware about the absence of the council and this absence of their and this council in two consecutive dates, as it was not informed to the petitioners petition post. However, subsequently, they have come to know that the council or the petitioner also could not appear on those two consecutive dates, that is on 2010 and 25 and 6/11/2025 due to his illness. However, during that period, the petitioner number one, who is 85 years old, had had developed cataract in both the eyes, and he was not even in a position to put his signature in any. He had gone for surgery only on 27/11/2025. However, coming to know about the order of injunction, the petition number 2 begged for a certified copy, and the copy of an order of injunction and this and certified copy of order of injunction was received only on 7/11/2025. 7/11/2025. But as per the advice of but after the surgery of the petition number one, the petitioner number 2 had applied for a certified copy of the order on 12/11/2025, 12/11/2025, passed in TS number 71 of 2025, and then only they have come to know about the order of the ex parte order passed against the present petition. Coming to know about the same, they immediately appear before. No. Coming to know about the no. I got your thing. 10/11 এখন first one. Yes. Indulgence. No. He can রাখো। But subsequently, and with full stop further, he submitted that it was not aware by the petitioners regarding the absence of his absence of their and his counsel, who also submitted an application on 10/11/2025 without mentioning the medical ground of the present petitioner, medical ground of illness of the present petition, which was subsequently rejected by the learned court below, with an observation that the petition was filed on 91 days of service of summons, and accordingly it is opined that the statutory period of filing the written statement is already over, and hence the order is passed. And hence the order of ex parte was passed against the present petitioners. Coming to know about this same, and also an advice of the respondent, petition number 1, the petition number 2 had immediately applied for a certified copy on 12/11/2025, and immediately after receiving the certified copy, the present petition has been filed for praying for setting aside and quashing of the order dated 10/11/2025, passed by learned civil judge senior division Jorhat in TS number 71 of 2025, whereby the case was fixed for ex parte hearing. Ex parte submitted by Mr. Submitted by Mr. Purva that if the petitioners is not allowed to file their written statement to bring their case, who also possess right title interest over issued property, will cause great hardship and irreparable loss to the petitioners, and accordingly submitted that the order dated 10/11/2025 may be set aside in court, giving one chance to the present petitioners to file their written statement in TS number 71. Hearing the interest submission made by the considering the grounds mentioned in the petition, vis-a-vis considering the medical ground of the petitioner number 1, and also for the ends of justice this court is of opinion that one opportunity may be given to the present petitioners to file their WS before Court of Learned Civil Judge Senior Division Jorhat in connection with TS 71. In view of this, the order dated 10/11/2025 passed by Learned Civil Judge Swain in case number Swain hereby set aside and post, directing the present petitioners file their written statement on or before the next date of listing without any further provision. According to the motion states itself. Oh, no issue. What is the date? There is a 19-1. 19-1, prior to 19-1, we don't have any date. So immediately after 19-1, February 1st, 4th of February.
In a compensatory suit, at the first instance, the learned court was taken into consideration to issue maintainability and find out the law of limiting. Now, so far the first issue is concerned maintainability, that has been decided positive. So far the limitation is concerned, that has been decided negative. Now it goes to the root of the matter. Once the issue has been decided negative in respect to the limitation, nothing happens. But despite of that fact, my lord, 13 lakhs of rupees compensation was decided agreed in favor of the plaintiff, and now we have been directed to pay the 13 lakhs on 12 months. Notice state the kind of case 50 of the
Page?
55. There are two issues: whether the suit is maintainable and whether the suit is barred by law. Now notice just take turn case 51. First line, and therefore issue number 1 is decided in positive and the issue number 2 is in negative. My lord, once suppose, my lord, it is the observation, nothing survives. Now notice statement turn to page 59. 59, 59.
No, no, where is the line? Issue number 1.
Decided positive maintainability. Issue
Where in page number?
Hello?
Page number, you're saying page number?
Page 50, 50. There are two issues. And page 51, my lord, the observation. First line, and therefore issue number 1 is decided in positive and issue number 2 is in negative. That goes to the root of the matter. Now, Lord, may I just take turn to page 59. Page 59. My lord, here is a decision to make a compensation of 13 lakhs. My lord, no reasoning on what text. It is not just kind of casual approach, my lord. A person is right to know that on what heads, my lord, he is liable to be 13 lakhs. It's my prayer that this is totally patent error on the face of the record. My lord, if you notice, my lord, till that point the person will be taken.
Now the proceeding, in a sense, it is disposed of.
Well, that has been disposed of. Education case is 12, where we have been directed to 30 lakhs. They have a further proceeding.
They have already filed their execution?
Yes.
Execution.
12.
No. Execution they have filed?
Yes.
Is any separate execution or?
Separate.
So what is the execution number?
Well, execution case number is 4/2020.
It's a money execution.
Okay. If not, the father posting automatically covers. Case 10 is the fair.
It's a case of Mizoram.
Hello, permission we have obtained.
Permission we have obtained?
Yes. That's why it has been written. because bench is not available.
I can. But yeah. Yeah. By Mr. S. Samaria, dependent on the petitioner. This petition has been filed after obtaining permission as the matter pertains to Mizoram Act. Next part. This is an application under Article 27 Constitution, read section 115 CPC, challenging the legality and validity of employment judgment and decree dated 12 May 2025, passed by the Learned Court of Learned Civil Judge Senior Division, Champhai, 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 Mizoram, passed in civil suit number 13, issue notice to the respondents, also called for PC. It is next by submitted by Mr. Samaria that in the present case, there were two preliminary issues were framed by the Learned Trial Court bill. Basically, number one, two following primary issues preliminary issues were framed by Learned Trial Court below. Number one, whether the suit is maintainable. Number two, whether the suit is barred by law. However, while deciding these two issues, issue number one, in regards to maintainability, was decided in favor of the plaintiff. However, the issue number two was decided in negative. But in spite of the said decision that the suit is barred by law, barred by law means which law?
Well, barred by law means limitation.
There is nothing.
Nothing, man. It's just a casual approach. Even my
Otherwise,
defense is
limitation point is discussed. Barred by law oblique limitation, which has been decided negative and goes against it. But in spite of said decision, the present respondent petitioner is directed to pay an amount of rupees 13 lakhs.
Without any reason.
13 lakhs without assigning any reason and without assigning any reasons for the degree of the said suit, which reveals that it is a patent error in the case of it. Accordingly, Mr. Samaria submitted that in the interim, the judgment and decree dated so and so, as by so and so, may be stayed till disposal. Considering the submission made by the counsel, let the employment judgment and decree dated so and so, passed by and so and so, case number so and so, be stayed.
Including execution case number 4 of it.
Including execution case number, money execution case number 4 of 2025, which state till next date of listing. List the matter accordingly after 4 weeks as on a date.
Well,
It's basically an injunction order.
Yes. Temporary. It's because that plot of land belonging to the school. That plot of land within them, the plaintiff here, the respondent, they will also assess for funding. Now they are that accordingly they suit necessary matter by claiming constitutional matter. In this case, generally, now the response is replaced by new melody and they will come here and here is case where hearing is the time that
Actually, my lord, today is fixed for hearing. We have some urgency in the matter because our dwelling house is there. So I will satisfy your
You
lordship.
got the injunction.
Yes, we have
Injunction is in your favor.
injunction in our favor both by the learned civil judge junior division and also that is upheld by senior division judge. Now they have come against the concurrent finding regarding injunction before this Honorable High Court. Now there are a pattern of judgment that against temporary injunction and that too.
Yeah.
That is why we are suffering because we cannot enter the house properly and they create unnecessary troubles. Now my learned friend has said the new agriculturists have entered there. That is absolutely false. That is not correct.
these are the they
No.
made dependent before
No. Now, I don't know.
why they are new.
Anyway, you need some time for hearing.
Yes, sir. Matter we will discuss for hearing.
But my lord, we are in trouble because Honorable Supreme Court has repeatedly said, kindly say I have given the judgments. First one judgment is Suresh Kumar Dhanuka.
Then it's okay. Now, if we are going to hear the matter only, then in a personally.
But
Because we don't have time so much.
but
time.
that stay order was obtained expertly in our absence. So we could not get.
Thereafter, have you filed any petition for vacating that
Yes.
stay order?
Yes. So when we have filed affidavit here also, and this order was passed in the year 2000 on the first part of 2005. So this injunction has created irreparable loss to us, injury, because there are our dwelling house. We have to go enter in the house, and we have given pictures also of our house in our affidavit. So when there is the prima facie case in our favor, 40 to 60 years we are in possession. And secondly, through Bosundara, the circle officer sent the mandal to see who is possessing the land. And they found that we are in possession, that we were allowed to file petition for obtaining patta. That we have annexed. So our possession is there. In that view, prima facie case is there. And our dwelling house is there. Balance of conveyance is in our favor. Now school is running. They say this is our land. Their land has been recorded much later. We have entered 40 to 60 years
Okay,
back.
then you want any date here? You want any date here for hearing?
After 4 weeks.
4 weeks. Actually, we are
In the-
kindly consider our hardships.
January, that's pretty nice. Fix it with it. January to very less number of working days left, in fact. So we have already fixed many matters in the last week of January. So he's saying that at best it can be fixed on 5th of February. 5th of February will do.
It's 4 weeks, almost 4 weeks.
There is no time also. If you vacation, yes.
Date is very now. Baby,
Actually, we had no problem because they are traveling as by dint of this Honorable High Court stay order. They are creating trouble. That is why we are in.
I'm sorry. Their injunction order is
very beginning under injunction order was passed, then it was referred to the appellate court said the same, and after vacating the say order, we have to go to High Court. Honorable High Court only from very beginning there.
My lord, the High Court's order is against the orders of the Honorable Supreme Court. When there are concurrent, no. Let me say, when there is concurrent orders in respect of injunction in favor of a particular party, and both the courts will be satisfied that they are in possession. Now, so far title is concerned, that part will be decided by the main case. Title suit is pending there. So why they should give a...
If there is still matter is pending for issue, they are not cooperating. So for my instruction is concerned, they are not cooperating with the trial court. If they do case, if they have to cooperate with the trial court, they resolve the matter, take their matter in favor of the instead of their
No,
pressuring.
that I shall have to receive instruction. That I shall be. Why? When the matter is pending in High Court, normally lower court does not proceed on. Normally.
Generally.
So I have to receive an instruction. If on that point I have no information. From where he is saying, when the matter is before the higher court, normally lower court is reluctant to proceed on further.
In trial suit is pending.
I can understand. Okay, anyway. Heard Mr. K. Rahman, the learned counsel for petitions. Heard M.U. Manda, the learned counsel appearing for the respondents. Matter is typed and considering the submission made by Mr. Rahman, let the matter be accordingly listed on 5th February. Will do 5th February. 5/2/2020.
No further that may kindly be granted.
Yes.
5/2.
Hearing Kula.
Yes, 5/2/2026. Be listed. It is hearing day, na? In the hearing column, irresistible to the need further, both the parties are hereby directed to proceed with the hearing on the next year.
On Tuesday or Thursday? Tuesday?
Without further action.
No further that may kindly be.
Yes, interim granted earlier, we continue till next year. Okay, we'll see.
Public.
Both are from same title.
Same titles. My lord may take up item number 7 first. That will clear the matter. It's your time. Yeah.
In both the matters, you are for the petitioner. Yes.
Yes.
For 180, from 180.
284.
No, he is saying 180 will be better to take.
180 would be better because, my lord, they want to adduce additional documents.
It is correct. It is amendment.
Matter is same, my lord.
Same,
Okay, so now you are treating which one? 284. Yes, please.
84 is the order.
84.
84. Yeah, this one. T220.
Yes.
take one. What purchaser of the land? What? But there are- Yeah, both are both. Yes, yes, then this is that you understand. We have that this there is property of that one one is other side one to other here. That this is that in the case is the case purchase after that. The original therefore one property that property partially and I have purchased from purchase. There we have taken the land take one select out of one quarter, three quarter, industry district. We are enjoying the long. Now they have had 2050 prices to that they allowed us to stay in the street and they do it.
Now, under what strength you are claiming right at lower day?
No, I am
They have claimed that they have this is the purchase purchase property of so and so. They purchase the property.
cases that they allow us as a relative, they allow us to live it.
No, that is permissible, sir. That is their case. What is your case?
Our cases we have
You also purchased.
purchased from the there is a three brothers of the original title holder. And there is a partition. If my yellow the three of my petition, yellow is there, but the fact is seven.
No, just tell me one thing that it is a case of the plaintiff that they have purchased the land and you were allowed to plaintiff their plaintiff case.
Our case is through inheritance.
Your case is through inheritance.
Inheritance.
You have not purchased.
We have not purchased.
So their case is of inheritance. And you were allowed to remain present possessed there as a permissive possessor. And your case is that one of the you have purchased the land from one of the patta holder or
three brothers there.
One of the original owner.
Out of three brothers, two brothers sent out their land. One Sarada Baby initiated. After that, Sarada Baby sent out to Baseta. And we have purchased from Baseta. 2022, and since then we are part by contracting with.
but the Youngest Council is not count. Youngest Council at the time of dividend counted that it is a petition for the hang out. Out. It when when petition listing that what are to dollar
This is your WS.
it is your my amendment.
Oh, yes, the amendment.
Amendment.
Yes.
Yes. Yes. Of course. Think of the future and after the brother will be what the student from that analysis project. They are the brothers of the first is the student from brother. Thereafter, Mama Kasset Ali said, first is the student from brother. They are all brothers. For the state and Kasset Ali said in 8/11/2022, register state. Last is brother international state land by Philippine Protestant. Due to number human alpha that so the student number one totally wants to amend then but amendment of the state is of the if then what but for loss only for of 20 for that yeah one okay only also for the constitution of is an advocate of When the case is transferred to the bank account, a new advocate so case the amendment is then will can get concept at the time of certificate that document also is a
Where the documents were already submitted.
the WS is not there.
That is the other CRP, ma'am.
That is the original WS is not mentioned, but newly understood is not noticed. Because it's high
No, those WS along with the original, you have not submitted all those WS. Subsequently only.
Therefore, it was not accepted. That is
So basically, what are the main documents you want to submit?
Yes, 35 and 30. That same date.
Sale deed.
Unregistered
So
sale deed.
your no,
And one
even if suppose unregistered sale deed, but you have not, because your entire case is based on the case that you have purchased the land from one of the original partner or say one, whatever, one some Baserali. That is your one of the plea. But in spite of this specific plea, you have not submitted any documents or any pleadings there. Now you want to allow. I mean, why?
One report also that is 35 candidates.
30?
35. 35. That they sort out that Sarada baby, it is report of the subsection of it is 30. You want to submit that.
No, at the time of filing your own WS, you don't possess any such kind of document.
But that document is not public.
But your plea was there.
Process is there. The document is not public. They are newly engaged counsel has found that it
Whatever, at the time of taking the plea in your W, that was a specific plea from your side because the plaintiff, as per plaintiff, you are the only permissive possessor. But as per you, you have purchased the land, maybe registered, unregistered, I'm not on that. But the question is that you have purchased the land.
In
That
fact,
is
my,
your own specific plea in the W.
well, in fact, they had made the prayer for submission of the documents twice, my lord. Those prayers were rejected, my lord. Again, they have filed this petition, my lord. Another third time, my lord.
That means after rejection of the prayer.
It was rejected in 2019, again in the year 2023. Thereafter, subsequently, again they have filed this petition.
They have filed this
Third
petition
time.
for amendment.
Amendment also, my lord. Additional WS they wanted to file, that was again rejected. Again, they have come up with this petition. Just to delay the matter.
initially 2019 was not accepted. Without amending the WS, you are not the London Council and without giving the filing additional evidence instead of filing amendment WS, they filed additional.
No, that is the issue.
That was
Procedure, you have to file your additional affidavit. Subject to question is that if there is any new ground, urgent ground which was not available, that there are some categories on in which area you can file your additional WS or can be amended or whatever. So this is your case now.
Case 35 and
It is a document, yes, inspection number.
Hindi, Sarada Bibi, and the Zainal Abdin and Papa. This total is the brother of the there's a special partition is there, among three brothers. Sarada Bibi initially purchased from the original purchaser Zainal Abdin and other. Son of Bhuan.
Now you are saying this is unregistered. Is it unregistered or registered?
It is registered.
Your registered document.
It is registered. Original purchaser ownership Sarada Bibi. Sarada Bibi purchased from original purchaser. Then your ownership Sarada is sold out. The next case ownership is 36. Sarada Bibi is sold out to purchaser. Next case is 30. It's also registered.
Registered?
Registered. Original is page 39. Page 36 your ownership.
পাশে তালি পাশে ফার্স্ট পাশে সারা we have
They have purchased on the basis of unregistered.
maybe, but their case is that
That is
they
their
have not sought
amendment,
out.
prayer
They
for
have
amendment.
asked as permission, but they sought out to another way. Another way sought out Basetan, and we have purchased
Unregistered.
This is the case. The document is vital document for set the case or here for rejected because they have some type of area. Yes, at any stage you can enter this. Now, High Court of any stage can enter this. That is yes. Okay.
Just tell, ask him to reply, make and reply here. Okay, yes.
My lord may take up item number 7, my lord. There they have produced the documents, my lord. Some orders are there, 2019 order, 2023 order. That is why I wanted to take up the item number 7.
Page number?
Item number 7, page number 76, my lord. This is an order passed, my lord, rejecting an application filed by them under Order 13, Rule 1 and 2 for production of the documents they have stated just now. My lord. Sale deed, my lord, sale certificate, everything. Copy of Jamaban. Page 76 is the operating portion.
Yes.
76 paragraph number 30, my lord. I have heard the learned arguments for both the sides. Para 32, I'm going straight away, my lord. The case has been filed in the year 2015. That is on 2/3/2015, the defendant appeared and filed a written objection in the same year. But after long 3 years, defendant filed his petition before this court. As per submission of the learned advocate for the defendant, the original documents were missing, but which was not mentioned during 3 years, nor any prayer made by the defendant side during the stage of documents. The learned advocate for the plaintiff strongly objected and submitted that already this case is disposed by the court by order dated 17/8/2015 with a direction to both the parties to maintain status quo over the disposal of the main suit. At that time, defendant did not raise the matter that some documents will be submitted by them. The case is in the stage of the plaintiff's evidence and cross-examination of witness of the plaintiff. The case is all pending one and filing by such petition is dragging by the defendant side. 33. On perusal, the petition filed by the defendant and written objection submitted by the plaintiff and their submissions, I found that at this stage, if the documents is allowed, there will be a new story out of this case. The defendant should have cross-examined the plaintiff witness and also adduced their evidence, as at no stage came for the defense evidence. In this stage, the petition filed by the defendant stands rejected without merit. Accordingly, the petition is disposed of. Original case is at the stage of examination of it. So, my lord, their prayer for filing the documents was rejected in 2019 once. Thereafter, my lord, after passing of this order, when they filed the written defendant's witness, my lord, they again exhibited those documents, which are rejected by this court, my lord. So thereafter, my lord, we filed an application under Order 13, Rule 7.2 that my lord will find at page number 45.
Yes, which para?
At
Page
page
number?
45.
Page 40.
Short order, my lord.
Yes.
Page 45, Miss case has arisen out of petition number 1480 of 22 filed by the petitioner plaintiff under Order 13, Rule 7.2, read with 151 of the court for returning back the documents of the defendant which were marked as exhibits but are not admissible in evidence and therefore cannot be a part of the record. That the main suit had reached the DW evidence, and at this stage the opposite party has submitted DW evidence in affidavits, whereby he had marked few documents as material exhibits to prove this case. Same documents, my lord. Moreover, the defendants had failed to follow the mandate of the court, whereby he had to take leave of the court if he is to submit any document at this stage. That the defendant had not mentioned of existence of any documents in his WS file on 30/6/2015, nor in his written objection filed in this case number 4 of 2015. Therefore, it is prayed that the exhibits so mentioned in DW evidence in affidavit be returned back to the defendants, as the same cannot be allowed at this stage. Written objections are called for. Same are submitted. Opposite side submits that he has made this error of exhibiting few documents which are new in his records, and the same way not being able to be made part of the record at any previous stage, so for the fault of the previously engaged counsel. Thereafter, if the prayer of the petitioner plaintiff is granted, then he shall suffer irreparable loss. The main suit has already reached the stage of DW evidence. Till then, the defendant has failed to produce any documents with the leave of the court. But it is only at the stage of DW evidence, defendants without seeking leave from the court tried to exhibit new documents which were nowhere mentioned in the record. At this stage, this cannot be entertained. Allowing such an act shall cause grave injustice on the part of the plaintiff's side. Finding merit in the prayer of the plaintiff, I am to hold that the exhibit which were mentioned in the record shall not be treated as a part of the record. In this case, 48 of 23 is thereby allowed. On court keeping a photocopy of the document, let the original be returned to the opposite side. So, my lord, the documents they have already tried to exhibit, those were returned back to them, saying that, my lord, it cannot form a part of the record. So again, now, my lord, they have filed this, have come up with this present petition, my lord, to produce the same documents, my lord. If this is allowed, my lord, there will be no finality to any of the order passed in the year 2019 or, my lord, this order, 2023. They should have challenged these orders, my lord. Without challenging this order, my lord, these orders have attained finality now. So by way of filing a new application, my lord, these orders cannot be reversed or reviewed. Now, this is with regard to item number 7, my lord. Now, since these documents were not allowed to be exhibited, my lord, they have come up with another formula, my lord, that is by way of amendment. My lord, they have, in fact, if my lord now takes up item number 6 at page number 54, they have already tried to put these documents by way of an additional written statement now. Order 8, Rule 9 of the CPC. Page 54.
54.
Page 54.
Yes.
They wanted to file additional written statement. At operating portion is at page 56, my lord. Excuse me. I'm reading for the second paragraph, my lord. Heard both sides.
Yes.
Heard both sides, peruse the case record along with the instant petition at the hand and the written objection. Also peruse the order passed by the Honorable Civil Judge Senior Division Kokrajhar dated 7/5/19. That I have just read, my lord. In the instant order, similar nature of prayer was decided by the Honorable PO, where the prayer was filed under Order 13, Rule 1 and 2, read with Section 151 of the Code, whereby the instant defendant petitioner sought leave of the court to bring new documents and record which were never mentioned in the pleadings. Presently, on the ground that in 2012, where the people of the residential area were involved in communal riots, he was found to leave all documents behind and leave the place temporarily, and same could not be submitted. Moreover, the Honorable PO decided that the main suit had already reached the stage of process of PWs, and if any party allowed to introduce any new documents, this shall bring a new story in the case. Therefore, the plea of the petitioner defendant is rejected, thus on the grounds that the petitioner holds no merit. Moreover, this instant petition is although filed by the petitioner under Order 8, Rule 9, read with Section 151 of the Code, to allow him to submit additional written statement so that new documents could be brought on record which were mistakenly already submitted along with the DW evidence in affidavit and marked as exhibit. Although the petitioner under which the present petition is filed and the prayer sought for is different, then which was already decided by the order dated so and so. However, the end goal in the present petition remains the same. The instant petition is also filed to allow the defendant to bring in new documents and allow him to mark them as exhibits on record. The same prayer was sought for in petition filed before the Honorable Court, Kokraja, that is to bring new documents. That since the previous prayer was rejected on grounds of merit, this instant petition as well lacks ground on merit. There is unreasonable delay of 8 long years from the date of filing the written statement. And this cross-examination of DWs, where I am not inclined to allow any prayer of bringing new documents at this stage, as this shall alter the suit nature and also may have effect on the grounds of defense by the opposite party, wherefore the instant petition. Henceforth, the instant petition is also rejected. So, my lord, thrice it is already rejected by the trial court, my lord. Now they have again come up with this additional written statement. And interestingly, my lord, the paragraph that they want to insert by way of amendment, my lord, that they have already inserted in the DWs, my lord, in the evidence filed for DW1. Without amending, they have already inserted that paragraph. Now, to fill up that lacuna, my lord, they want to amend the written statement, my lord. That cannot be allowed, my lord. Number of decisions are there, my lord, to fill up the lacuna or to fill up the omissions or submissions by any of the parties. Amendment cannot be allowed. The PW, my lord, they have already annexed a copy. Now, my lord, will find that they have already produced the documents DW1. My lord, may kindly have a look, my lord, at page 42. Page 42, 41 it starts, 42 is the operating portion. Paragraph number 5 and 6 that my lord has seen. Those are the paragraphs, my lord, that they want to insert by way of amendment. The genealogy that they have given, first they have Joyed Ali Sheikh and Muhammad Abdul Sheikh, my lord. Now, this paragraph number 5 and 6, they want to insert without amending the application or a written statement, my lord. They have straight away produced this document, paragraphs, my lord. Now, to fill up this lacuna, my lord, they want to amend the written statement. That is my respectful submission that, my lord, this cannot be allowed. And even if it is allowed, my lord, they won't be able to produce the documents because those have been already rejected thrice by the learned trial court, my lord. So, what benefit will it survive? And regarding the other point, the court has dismissed the petition on 2 grounds, my lord, cause of delay of 8 years. Another point is that, my lord, if the amendment is allowed, then it would change the nature and character of the suit. Why the nature and character would be changed, my lord? Because para 6, my lord, if my lord sees, they have purchased it from Basir Ali Sheikh. If I go from bottom up, Basir Ali Sheikh purchased it from Sarda Devi. Sarda Devi purchased it from Joyed Ali Sheikh and Abdul Wahaz Ali Sheikh. Now, Sarda Devi, that she purchased the land in the year 1980, that was never mentioned in the written statement. They have stated straight away that Basir Ali has purchased it from the original vendors, madam. If now this way the amendment is allowed, that would change the nature and character. And plus, they have nowhere stated in the written statement that they have purchased the suit land by way of an unregistered sale deed. Now they want to say that they have purchased by way of an unregistered sale deed. Even if, for argument's sake, if I agree, my lord, that they have purchased by way of an unregistered sale deed, unregistered sale deed, my lord, knows more than, if the land value is more than 100 rupees, it is not going to confer any right title interest on them, my lord. So what purpose would the amendment serve? Just because, my lord, if amendment is allowed now, DW stage it is pending, then it would again relegate back to the stage of evidence, to the filing of written statement. So the suit will again go back to the stage, my lord, square one. So if this is allowed, my lord, 2015 suit, 2025, if they are allowed to file the written statement, amended written statement, 10 years have already gone by, my lord. My whole 10 years would be lost. So this would cause unnecessary delay, my lord. And for proper adjudication of the suit, my lord, already whatever documents are there, that is sufficient, my lord.
Then it-
Eight. 32.
284.
Yes.
Yeah. 20%. One. Area of Tubika in the south of the Bangladesh and of the number directly originally it is called Sarada, then after that you have got short. Yes. Then Sarada is called Bak. Yeah. That's why that's here. It's anything else. We have connect all the order. At any stage in the text. The stage of RSA. Yes. Here is there. They said that we have found it. Therefore, yeah. That any stage we can amend.
That is to settle. There are no dispute. Sit. Reading of all paras. 5, 6, 7. Yes, already.
So the also delay as because by the accident there is no ground for future fear of Playground.
It's okay. I will go. Okay. That's for the response.
I'm for the respondent.
Yeah, that's yes, sir. Yeah. It- it can be cut in.
Hey, Dylan,
Any like in the evidence clearly pointed. You have already appeared for whom? For the
My
respondent
lord,
number
I'm appearing on behalf of respondent number 1.
1.
Yes.
1 is the claimant.
Yes, my lord. My lord, let the amount may be withdrawn by the claimant.
Where is the amount? Yeah, they have not deposited the amount. How can you withdraw without depositing? Main April 15th. Card MS Elsham, the learned counsel for the appellate. You are MS?
S. Ahmed.
Yes, Ahmed. Your name is not here. You are appearing for someone?
I'm appearing on behalf of Advocate S. Roy.
S. Ahmed, appearing on behalf of Mr. S. Roy. The petition. This is an application. 1970. And judgment and appointed 2011. Filed by learned additional learned member MSCT Karimganj in MSc case number 47 of the 2015 18 will be edited, issue notice to the respondents. However, no formal notice is required to be served on respondent number 1. The appeal memo may be served during the course of the day. Issue notice to the respondent number 2 speed post and process. Is the matter. This is your I. We are ready to deposit 50%. And any objection in withdrawing that one? We have only deposit 50%. Prayer for withdrawal. Huh? No, but I'm just asking you. You have raised the issue of not having the valid driving license. So in that case, do you think the withdrawal of deposit will be any problem, or if it is not? After people want, huh? Deposit won't. In that case, you don't have any objection. No, because why I'm asking, because your appeal is based not on quantum. Quantum may be different, but the quantum is not the case. You are taking the plea of having not valid license. The driving license was not valid. So in that aspect, do you have any objection or no? So there is minimum amount. Huh? Minimum amount means? Yes. The amount is 1 lakh and 195. Okay, acha. I do. MS Elsham, the learned counsel for the applicant and also third MS students Ahmed appearing on behalf of Astro for the respondent. And this is a application for stay of operation of judgment and award dated 22/11/3 passed by learned member MSCT Karimganj in MSc case number 47 of the 2015 is submitted by MS Sharma that by the present petition they paid for stay of the judgment and award, which has already been passed, as they have already filed a connected appeal challenging the said judgment and award, and basically on the ground of not having the valid driving license. Considering this submission made by MS Sharma that the operation of judgment and award dated 22/11/2023 we state till disposal of the connected appeal subject to payment of 50% of the awarded amount before the registry within 6 weeks from the date of award. Next para. Also considering the prayer made by MS Ahmed, the learned counsel for the respondent number 1. The claimant respondent is the deposited money may be disbursed to the claimant respondent number 1 by the registry after proper and due verification and on condition of furnishing an indemnity. With the above observation, the IA stands.
Much appreciated.
Will appeal.
arising out of the judgment exam. Along with the subject, my lord, I have also filed to IA. The IA number 7, my lord, is the application of the order 41 rule 5, praying for stay of the June or the judgment in decree. And the other IA, my lord, is filed under order 41 rule 27 for educing additional evidence, my lord. Not be placed for the learned court below. And that primarily consists of the records of the proceedings that culminated prior to the institution of post. My challenge is primarily on two grounds. Firstly, on the quantum of the permanent eligibility of 4 lakh, the wife, and the second is the cost of proceeding.
She is appearing there. Yes, yes. Yes, yes, to serve a copy.
This is actually a meeting appointment.
No, no, no. Earlier she was filing the bail application on behalf of these two.
Yes.
But now before the trial court also she is appearing or she is not appearing? She's still appearing. Okay. Then it's good only. Heard Mr. K. Brook, the learned counsel for the learned. You are appearing on the strength of Junior Standing Counsel, DRI. Standing Counsel, DRI. Full stop. From the office note dated 6/1/2026. It is seen that the service report on respondent number 2 is completed and the notice has been received by the father of the respondent number 2. However, Mr. Brook submitted that with available information, it is learned that the respondent number 2 is not available in his residence and he is in residence since 2023. Full stop. Further, from the office note of 6/1/2026, it also reveals that the notice is returned unserved to the respondent number 1. In that context, in this context, Mr. Brooks submitted that he made a contact with the engaged counsel for these two petitioners before the learned trial court below. And to serve the notice on both the respondents through the counsel if it is or you can take once through your judicial police station, but same report will come or what? We are still awaiting service for the respondent number 1. So do one thing, you can try. I have already reflected through the council, and apart from that, through judicial police station also, you can just serve a notice. Right? Further, Mr. Brook is hereby directed to issue notice to both the respondent number 1 and 2 through judicial police station. Judicial police station. This matter accordingly. After here, I don't think a fixed date is required. Fixed date. 3 weeks. This matter accordingly after 3 weeks as an entity. You just try is one. Otherwise, the matter will be disposed of and your petition will be lying here only. Oh.
Thank you. Right, but like so we can allow the testimonial evidence. Yes.
That was yet to be numbered, I think. Na?
Yes, yes.
So there was a delay.
There was a delay putting the on.
Yes.
But fine. If there was kept that public because what if the you have was there over to then what last but was fall on the part of their council and in the month of August. So later on he came to notice some their application. proper. So, like to
Withdraw.
file and file a fresh one with a liquid. But
So liberty is a question when if your appeal would have been suppose registered. Now your appeal is not in existence. So you simply withdraw the IA as with that the matrimonial appeal is which is not yet numbered or not yet registered, maybe accordingly withdraw. Just file it under. We're not going to suppose anything because liberty, we cannot give you a liberty to file a delay conversation application. It may be a case or appeal you may seek for that liberty, but not otherwise.
the other not yet to be numbered.
Yet to be numbered. So we cannot pass any order to for allowing the liberty, but we are simply allowing you to withdraw. Just file it after 2 days because it is not yet numbered.
Along that I along with the matrimonial
Oh, yes, yes,
Yes.
both will be withdrawn.
Got
You are Mr.
SR Burma.
Hard Mr. SR Board responsible for the applicant. I to take. Mr. Purva accordingly submitted that he has been newly engaged in the present case. However, without consulting the petitioner, the present IE has been filed seeking for delay condonation, and which bears some formal defects. According as per instructions of his client, he wants to withdraw the same along with the matrimonial appeal, connected matrimonial which is yet to be numbered and registered. Considering the submission made by Mr. Purva, the present I so and so is hereby disposed of on withdraw, and the connected matrimonial appeal which was yet to be numbered or registered is also disposed of.
Lovely.
Yes. You have already appeared for 3.
3.
For 3.
One.
1 day. Acha. You are for the claimant. You are Mr. A.U. Ahmed. Appearing on behalf of Mr. K. Bhattacharya. K. Bhattacharya, Learned Counsel for the applicant. So far, Mr. A.H.A. Saikya, the Learned Counsel, appearing for the respondent number 3. This is an application under Section 5 delimitation for condonation of delay of 1 day in preferring the connected appeal against the judgment and award dated 8/03/2022, passed by Learned Member MSc Sonitpur in MSc case number 53/2021. Post. We have why 1 day delay? Is there any explanation? Simple explanation. Paragraph number 3. No, there is no ground at all. You have submitted an appeal innocent and there is no willful negligence. I can understand. But why 1 day delay is not at all explained. And it is submitted by Mr. Ahmed that the applicant appellant is
Your ladyship, this is as per your petition, paragraph 3, financial constraint is shown that advocate fees they could not.
pay. What so?
Financial difficulties, paragraph 3. Lord.
paragraph 3 of the petition.
Yes.
No, that's why there's written that there's applicant is innocent, only innocent, and there's no willful negligence.
In our petition, it is written like that due to financial.
Page number 3. Para number 2. But
They
you're
have-
saying that para number 3?
They have written it three. Actually, it is three. It was some handwriting is there. In my petition also, it was earlier two, but it was made three in my petition.
Oh, haha.
Yes,
But
that
you
is
have
the
not made
problem.
correction here.
Yes, yes.
Okay. Submitted it only due to financial difficulties. The applicant could not arrange for an advocate to file the appeal within time, and hence there is a 1-day delay in preferring the appeal, which is not which is delay. Full stop. There is no laches or negligence on the part of the present appellant. And accordingly, he submitted that the delay of 1 day may be conducted. Mr. Saikya, the learned expert, Mr. Saikya, the learned counsel for the respondent number 3, raised no objection here. Considering the submission made by learned counsel for both sides, considering the ground mentioned in the petition and the number of delay in preferring the connected appeal, the present I is allowed, condoning the delay of 1 day in preferring the connected MSc appeal against the judgment and awarded dismissal. In view of this, the I stands disposed with the direction to the registry to list the connected appeal after being registered and now.
Also, our name may be shown in the cause list also.
Here it is shown. Oh, there.
In appeal.
Pardon. The registry is hereby directed to reflect the name of Mr. A.S. Saikya, the counsel for the respondent number 3, as and when the matter will be listed. No, yes. Hearing? The hearing paper. Who is appearing for the other side?
Yeah.
Huh? You are for the other side?
Malan.
He morning hours he prayed that with the
Only
consultation with
jurisdiction
you.
question, Malan, that is the issue. in
Your consultation, he prayed for upgradation of the
That is-
hearing.
Yes, in
So
at two-
accordingly, we thought that it will be heard at 2 only. At 2. Okay. Remaining matters are all all the hearing matters, so it will be listed at, yes.
Item number 17, my lord, can it be taken in the first week of February?
1-7.
1-7. And for the respondent number 1 and
only thing is also in particular case, this benefit, I have prepared a case. That is my part. Their part may be harder to do it.
Part heard may not be, because now morning hours only I have received a phone call from the registry. Suppose my bench may not be here on the after January. That is the main question. Remaining part heard is very problematic. Otherwise, I have seen it is a case of 2019 also. So what is your problem?
Today, my lord, only today, my lord, we have some difficulties. We could not prepare, my lord, some personal immediately after vacation.
Because otherwise also it was in the first, it was in the hearing column, it was the first item, in fact, RSA. So do you want any fixed date here?
Maybe
Yes,
can
Gustami,
be,
do
my
you
lord.
want any fixed date here? Problem. So it will be otherwise immediately after vacation or first week of February? First week of February. At a request made by the learned counsel for a respondent, matter is adjourned, to which Mr. S.K. Gusam, the learned counsel for the appellate raised objection, raised the matter accordingly on first week of February, as on a date to be fixed by the registry, with a direction to both the sides to proceed with the hearing or the next. Item number?
Hearing.
Yes.
My lord, I'm the respondent. My lord, and is appellant for enhancement.
No.
Maybe
You are for the respondent.
Yes, yes.
It is
Insurance
for the
company.
enhancement. So what do you want to say?
My lord, fixed on first week of February.
Will do.
In the meantime, my lord, I may be allowed to see this lower court record.
In the here in the court itself, you have to see.
My
You
lord?
have to peruse the record in the court itself.
Yes.
Now we have some
Yes, I understood,
instructions,
my lord.
that's why I'm saying.
I'll inform in the morning.
At a request made by the counsel for both the parties, let the matter be listed for hearing on the first week of February as on a date.
Maybe date may be fixed.
One fixed date here?
Yes, it is. One
5th of February. It is
my
a
lord,
hearing day.
my lord. Much obliged. Baba?
Which one? Which one? Item 22. You are for the which page? You are for the appellant or respondent? No, MU Muhammad means appellant. Have you taken consent of the other side also? You are for the respondent. They have not taken any consent from you. Anyway, they have some most probably difficulty. He has some difficulty or what? Your senior has some difficulty. You are MS? Heard MS SC appearing on behalf of Mr. M.U. Mahmood, 22 to Likho for the appellant. And also heard. Yes, your good name?
Lordship, A. Tapadar.
A. Tapadar, appearing on behalf of?
R. Chaudhary.
Appearing on behalf of R. Chaudhary, the respondent. Considering the submission made by MSC, the matter is adjourned. Let the matter be accordingly listed on first week of February will do, or you want any fixed? List the matter accordingly on the first week of February as on a date be fixed. First week of February we are listing it. Yes,
Lordship. Lordship, I have a prayer to make, Lordship, because one case is fixed today for hearing, my lord, item number 20. Lordship, to be ready for argument, my lord, we need to see the TCR, my lord. I seek for Lordship permission to go through the TCR, my lord.
TCR want to see. Achha. You are for the here, you are for the?
I'm for the respondent, my
For the respondent. Who is the plaintiff, sir? Mr. Sahibwala's name?
Yes, yes.
You can.
Much.
But during the court hour,
My lord.
in presence.
My lord.
We can also react to the 19 TCR.
Now see, one matter will be heard at 2 p.m. 25. The rest, I don't know how many matters will touch today. You can peruse, no issue at all. If it touches.
Item number 20. Other side is also present.
Otherwise, you have gone through the case record.
No, my lord. We are going to see the record
See
now.
now.
Yes.
Oh,
Today, my lord, we are praying for adjournment.
Maternity. First week of February, or you want any fixed date here?
10th of February. 10th of February.
Okay, that.
But much.
$25. अच्छा.
One. The absence of ability.
So the only substantial question of law is there whether the learned lower court, lower appellate court has the right to set aside the judgment and decree passed by the learned civil judge Hailakandi in matrimony. But learned civil judge junior division Hailakandi can file matrimonial will what kind of? It was a restitution.
No, man.
Divorce.
Divorce. Parties are.
No. This I have not gone through the entire record. Just I'm saying that from your substantial question.
Yeah.
Here it is rightly set aside the judgment and decree passed by the learned civil judge junior division.
Yes, Munshi.
Munshi passed the order of divorce.
Divorce is already pronounced as per Muslim law.
Oh, acha,
Both
as
the
per
parties are
Muslim law.
The already pronounced as per Talaq-e-Hasan.
Oh, acha.
It is there. So the in a district, the court is not there. The divorce already pronounced as per Sharia Act. Talaq-e-Hasan, that is a divorce, written divorce pronounced in 3 months. The Talaq-e-Hasan is pronounced. So the suit is only filed for declaration. For declaration, it is a declaratory suit, not for a decree of divorce. And that is the learned trial court in details explained. I will read the judgment. It is the learned trial court. This issue is discussed by the learned trial court. So may I read the judgment? Is a short judgment. May I read the judgment of the trial court?
Yes, in page number.
Yes, I can go to the page number 12, the issue. It is the issue. Sorry, it is the judgment. There is page number 24. There of the page number 24. Paragraph number. Initial suit has been filed by the plaintiff praying for following reason. A decree declaring dissolution of marriage dated 25/7/21. It is already pronounced the talaq. The talaq. I will go to the report. Then the talaq. So that was 25/7/21. A decree for confirmation of written divorce. A decree for declaration that the marriage between plaintiff and defendant is dissolved. So it is not a suit for divorce to be granted by the munshi. It is one important aspect, your lordship. For first, now your lordship, the paragraph 4, someone was served upon the defendant but he failed to submit written statement. The suit proceed ex parte. So it is decided ex parte. It did not contest the suit. For determination of this suit, following points are formulated: whether the marriage between plaintiff and defendant is dissolved upon talaq by the plaintiff, whether the plaintiff is entitled to the decree as prayed for. The plaintiff has adduced his evidence along with the evidence of 3 other witnesses who are attesting witnesses of the divorce notices and a person from defendant's locality. PW1 plaintiff has also exhibited the document relevant to the suit, including the 3 divorce letters and the postal receipt and certified copies of deposition of the defendant and her witnesses in the domestic violence case filed against plaintiff. So in the domestic violence case is also going on there. The wife admitted that she has received the divorce notice. PW1 has reiterated the facts which are asserted by them in the plaint. PW2 has also stated in the plaint the line of that plaintiff and he has admitted his signature the letter of attesting witness. PW2 is also another witness of the exhibit 1 to 3. 1 to 3 written divorce letters. The witnesses has been reduced as PW 1, 2, and 3. Has admitted the execution of the same by the plaintiff in his presence, and he also admitted his signature. PW4 is a neighbor of defendant, and he has also deposed in favor of the plaintiff and corroborated with evidence of the plaintiff, stated that himself intervened in the matter between the parties and tried to resolve the same, but defendant's father did not agree to it. So before the pronouncement of talaq, there was well-wishers of both sides tried to resolve the dispute, tried to conciliate the matter, but it did not fruitful end. He even stated to me the father of defendant with the Mohalla Masjid committee members, but defendant's father gave no response to the marriage between the parties has dissolved, and the plaintiff is entitled to receive a paper. PW5 is another attesting witness of the talaq notice, and he has also corroborated with the other witnesses and stated that plaintiff executed the witness notices in his presence and he put his signature therein. He has also admitted his signature in exhibit 1 to 3. Before going into the decision of the matter, it is firstly to be mentioned that the plaintiff is seeking declaration. It is to be noted. The learned trial court explained. It is firstly to be mentioned that the plaintiff is seeking declaration that the defendant is divorced wife, and he is not seeking divorce from defendant in this instance. From perusal of the plaint, it is seen that plaintiff already divorced his wife, defendant on 3 different dates, as mentioned above, by pronouncing talaq for the 3 times within interval of 1 month and more. Unless there is a dissolution of marriage, there cannot be a declaration to that effect. As the plaintiff has stated about pronouncing talaq in interval of about a period of 1 month for 3 times, it becomes talaq-e-hasan, which is not prohibited under the law. Upon perusal of the exhibit 1 to 3, that is the divorce, it is seen that plaintiff sent divorce notice to defendant within the prescribed interval of time, and that he waited for her to return and reconciliation. But defendant has not returned to him and continued their conjugal life. In such a situation, the marriage can dissolve. So, as per talaq-e-hasan, after doing the first divorce letter, if the wife came back to his parents to her matrimonial house and resumed the conjugal life, then it becomes secret. But in this case, after receiving the 3 divorce, he did not prefer to return back to her house. So if he did not return, then it becomes valid. First, talaq becomes valid, and then the second talaq is pronounced and the notice is given. Then she had the option to return even after receiving the second notice. And likewise, after second notice, the third notice, it is effective after pronouncing the third talaq. If she did not return in the first and second during the 7. In this case, she did not return even after receiving the return divorce letter. And also she did not dispute that. She did not contest the suit, dear Lord. Even after receiving the summons, she did not contest, she did not deny the receipt of the divorce letter by adducing evidence for by denying. She even did not file the written statement. So paragraph number 8, the defendant is summoned but failed to contest the instant suit. In such situation, the evidence produced by the plaintiff side has to be looked for properly to see whether plaintiff is able to prove his averment. And in the instant suit, plaintiff and his witnesses have corroborated the averment made in the plaint, and the documents are also found in support of the claim of the plaintiff. Plaintiff has succeeded in establishing his claim against the defendant. Both the points judgment. So this judgment came into appeal on the Lordship 6. Page number 6 is the appellate judgment.
Page number?
Page number 6. The Lordship, now the point before the appellate court, the civil judge, page number 6. Page number 9, the points formulated by the page number 9, paragraph number 5. On the basis of the pleadings of the plaintiff, the learned trial court has changed. After hearing the learned advocate of plaintiff, Jose Medeles records the learned trial court agreed the suit. Being agreed, the ground is there. So I may not be the ground. Next, page number 11. Page number 11 is the point, paragraph number 9. Whether the civil court decided about by learned civil judge has got any jurisdiction to the entertain the suit relating to the dissolution of the marriage. Whether the marriage between the plaintiff and the the learned civil judge first question is the jurisdiction. The point is framed. Now, page number 12. Point is whether the civil court has a jurisdiction. Peruse the pleading of the parties as well as the evidence on record reveals that the plaintiff had insisted the suit for the dissolution of marriage on the ground of triple talaq pronounced by him on the different day. Now, if we see the Quran before which the relief is brought to the court of learned civil judge junior division, which is, in my considered opinion, has got no jurisdiction regarding the declaratory suit relating to the matrimonial dispute like dissolution of marriage divorce. The proper forum competent court of the lowest grade, considering the subject matter of the suit, which is not an ordinary civil suit, whether it is a family which is governed by its own specific laws, procedure, and objective, in my considered opinion. So it is not as per law, as per provision of any law, it is the view of the learned civil judge, appellate court. In considered opinion would be family code. If the family code is established for an area as per section 378 of the Family Code Act, and if no family code is established, then it would be the district code. So this finding, my lord, And if no family court established, then it was the district court with family jurisdiction. And we know that in view of the two court of jurisdiction, is general cause and effect. District court with family jurisdiction would be the principal civil court of original jurisdiction, that is honorable district judge. So in view that matter, I am of the considered opinion that the learned civil judge has got no jurisdiction to entertain the suit relating to the dissolution of marriage. However, before parting with this point, for determination, it is pertinent to deal with the submission made by the learned during the course of the argument for the just case. Learned advocate for the appellant side during the course of the hearing submitted that secondly, there is a practice of instituting cases relating to dissolution of Muslim marriage before the court of learned civil judge junior division since long, and with regard to the dissolution of Hindu marriage, they used to file suit before the court of civil judge. So on the ground of that practice, according to the learned advocate, it is the term on marriage. So this submission was, my lord, for that the Hindu marriages prepared as per Hindu Marriage and Divorce Act before the district judge for resolution of the marriage, not for declaration. This is not a declaratory suit. And under the special act, also those acts, the divorce cases are filed in the district judges court because for dissolution of the marriage, not for declaration of the divorce. So that is the difference for which in other districts also the cases under the Muslim laws for declaration that declaration of the divorce, decree of divorce, for declaration of decree of divorce, the case is filed in the other district also, not only in the other district also. And since the in case of Hindu Marriage Act and the Marriage Act, those for divorce, for passing a decree of divorce, the cases are filed in the court of district judge. So this submission is recorded. I have heard the learned advocate. I am of the considered opinion that the submission of learned advocate cannot be entertained because under Indian Constitution there is no such provision which states that a separate court in respect of the same subject matter on the basis of religion and community shall be created. In my humble opinion, the Indian legal system is secular, with all the citizens subject to same procedure of law and court, and the statute cannot be interpreted in the way the fundamental principles are reached. In the district court, he is competent to deal with the matrimonial issues under Hindu Marriage Act in absence of family court. Then the same district court would be equally competent to deal with the matrimonial issues under the dissolution of Muslim Marriage Act in absence of family. So this is the finding of the learned appellate court, that if the divorce cases are filed, the marriage act then the special act then so that should also be filed before the. But the difference was that I have explained the logic. That it is a declaratory suit. The learned trial court already held and already explained this issue. That it is not a decree of divorce. It is a declaration that the divorce is already pronounced. Only the declared dictum. That the learned court of civil judge is neither a court with an equivalent jurisdiction, competency, or authority to that of the family court or with that of district court. On the other hand, the family court and the court exercise equivalent jurisdiction in respect of the matter relating to matrimonial dispute like jurisdiction. Hence, under the above, I am of the possibility the submission of the land certificate. Know what? That in the light of the foregoing, I am constrained to hold that there is an inherent lack of jurisdiction as such that the decree passed by the learned trial court is nullity and is not enforced. So the appeal is dismissed on the ground of jurisdiction, is not on merit. Now, if the provision of law referred by the learned appellate court that section 2(4) of CPC may I read? 2(4) of the CPC means the local limit of the jurisdiction of the principal civil court or original jurisdiction called the district court and includes the local limit of the ordinary original civil jurisdiction. So, and the jurisdiction of a district court is said. The Government Project Act 1 provision is referred. It is section 3, 17, 17. It reads district judge. 12 means the judge of principal civil court of the original jurisdiction will not include a high court in the practice of the ordinary or original civil. There is no dispute that regarding the principal civil judge of the district court. No dispute. Now I refer to the Family Court Act. In the question right for the family court. Family court. The other provisions of this act, a family court shall have and exercise all the jurisdiction accessible by any district court or any subordinate civil court under any law for the time being court in respect of food and proceedings of the nature and to be deemed for the purpose to be a district court or as a court. If there is a family court, then these provisions will. Now, explanation A, your lord. A suit for proceeding between the parties to a marriage for a certificate of marriage, declaring the marriage to be null and void, or as the case may be, annulling the marriage for acquisition of conjugal rights or dissolution of marriage. So the question arises when there is a family court. So in the since there is no family court, so these provisions will not be applicable in the district of Thailand. Next, your lordship, a suit for proceeding for a declaration as to the validity of a marriage or as the criminal status of any party. So if there will be a family court, then this suit will be before the family court for status of the party. It is for declaration that the talaq is a valid court. It will be before the family court. If there is a family court. Now, close to jurisdiction, section 8. Where a family court is established. If there is a family court. If there is a family court, then no district court or any subordinate civil court referred to in the subsection 1 of in relation to that area have or exercise any jurisdiction in respect of any civil proceeding of nature referred to in explanation that no magistrate in relation to that area. So, in the then the jurisdiction will be part of it. So, since the learned appellate court did not pull the matter on merit, well, at least only on jurisdiction, so one this judgment is followed by the Honorable Court in according to the Honorable Court in Tikaram, Nepal. I have earlier occasion I have submitted a copy of the report. So this is the 2017 9 SCC 591. Kumar Kumar Rai, who yes, but I will refer to paragraph 14 is the section of the family code. One paragraph 15. One a reading of the aforesaid proposition is clear that the examination of the remedy provided in the scheme of the Marriage Act and of Special Marriage Act law that the statute creates special rights for liabilities and provides for termination of rights relating to marriage. The Act do not lay down that all questions relating to the said rights and liabilities shall be determined only by the tribunals which are constituted in the said Act. Section 8 of the Family Code Act excludes the civil court jurisdiction in respect of a suit or proceeding which is between the parties and filed under the Hindu Marriage Act or special marriage. Where the suit is to annul or dissolve a marriage or is for restitution of conjugal rights or judicial separation, it does not purport to bar the jurisdiction of the civil court. It's important. And this finding is, my lord, in presence of the district family court. It does not purport to bar the jurisdiction of the civil court if a suit is filed under Section 34 of the Specific Relief Act for a declaration as to the legal character of an alleged marriage. So the Honorable Apex Court held that even in the presence of a family court, a declaratory suit can be filed in a civil court. Also, as was pointed out, an exclusion of the jurisdiction of the civil court is not readily inferred. Given the line of judgment referred to by the High Court and given the fact that a suit for declaration as to legal character, which includes the matrimonial status of parties to a marriage, when it comes to marriage which allegedly has never taken place, either de jure or de facto, it is clear that civil court jurisdiction to determine the aforesaid legal character is not barred either expressly or impliedly by any. In this case, under the husband has denied the solemnization of the marriage, though the wife had claimed that she is the legally married wife of the citizen. The Honorable Apex Court held that in such a situation, even in the presence of the family court, the civil court has a jurisdiction. And this Honorable Court, I have a copy, Sitaram Pal. Sitaram Nepal by Kumbhika Devi.
You earlier submitted.
On the report judgment,
Just tell us, please, what was the order?
Your Lordship, Nepal. the Bhumika Devi.
Okay, we receive anyway.
Paragraph number 14.
Paragraph 14.
Paragraph number 14. The Supreme Court referred at number 11. Second, the already read about, and this honorable court in paragraph 14 held that I have decided to agree with Mr. Picture when the admitted that the family code would be applicable where there is a family code and at Sunitpur there is no family code. Paragraph 14. So the citizens of Sunitpur has depend upon the available codes there. They cannot be compelled to travel to another state or city to get relief. Moreover, Section 8 of the Family Code Act excludes civil court jurisdiction in respect of a suit or proceeding which is between the parties and filed under the Hindu Marriage Act and or Special Marriage Act, where the suit is to annul or dissolve a marriage or is for restitution of conjugal rights for judicial separation. It does not purport to bar jurisdiction of the civil court if a suit is filed under a declaration as to the legal character of an alleged marriage. For supposed reason, the learned Munshi as well as learned civil judge Sunitpur both seem to have erroneously oriented themselves and arrived at incorrect findings. In that case, the Munshi had dismissed the suit on the point of jurisdiction. The civil judge also dismissed. The suit filed by the present appellant is maintainable in a civil court. Therefore, the impugned order of dismissal of the suit by the Munshi by the judge. Regarding these state orders are set. So, this is that honorable court had already decided that the civil court has the jurisdiction. And regarding the distinction of the Munshi and the district judge, your lordship, is there that is a case, this is a declaratory suit. The as per Muslim law, the divorce is already pronounced. The talaq is upon divorce is already, and only for declaration that the for a that the valid divorce as per law it is passed, the declaratory suit is filed. And the learned appellate court art in law and in law in misinterpreted the provision that of the that it is a declaration not a suit for a divorce. That is the point. In case of Hindu Marriage Act and the Special Act, it should have been filed to the district judge court because it is a divorce for a degree of divorce, for passing a degree of divorce. And this is a case for not a degree of divorce, it is a case for declaration that the divorce is already the divorce is effective as per me. My humble submission is that in this first appellate court, it does go to the merit of the case and only on the point of jurisdiction is dismissed. So the matter may be submitted for disposing of the appeal on merit by citing the of law. Right.
Yes.
Well, the issue is, my lord, possibly simple. Now, whether the civil judge junior division has jurisdictions to entertain this type of suit or not. Civil court has the jurisdiction in absence of the family court. It is admitted. There is no need. Now, in which forum? This is the issue. The learned's lower appellate court held that it is a district judge, not the civil judge junior division, because it is a dissolution of marriage, and for declaration of dissolution of marriage, so it will go to the for a district judge. Yes, each subordinate court also can do. If it is filed before the district judge, if power is delegated to a civil judge, it can be. But it is not that on junior division can entertain this. And this issue was raised by the learned lower appellate court. It was not raised by the wife respondent here. And now question of jurisdiction, it is in Family Court Act, like your lordship, and the why this section 7, 8, and 9 was referred. In Family Court Act, in section 7, what type of my lord suit can be decided by family court, and what type of suit was transferred from family court to district judge when section 7, my 1, section 7, subject to the provision of this act, a family court shall have and exercise all jurisdiction exercisable by a district court. A district court already defined as a district judge in general, or any subordinate civil court under any law for the time being in force. That means it is referred, or any delegated the power, it can be any civil court can. In respect of any suit and proceeding of the nature referred to in the explanation. Kindly see the explanation. The suit and proceeding referred to in subsection are suits and proceeding of the following nature, namely a suit or proceeding between the parties to a marriage for a decree, nullity of marriage, or restriction of conjugal rights, or judicial separation or dissolution of marriage. Second one, a suit or proceeding for a declaration as to validity of marriage, or as to married matrimonial status of any person. If it is so, family court will entertain in the if the district if family court is there. If not, then my lord, this type of matter will be decided by the district judge, because 7.1 it is called district court. So only that issue may be decided, maybe look into the whether junior civil judge junior division has the jurisdiction or that part. And so far merit is concerned, my lord, that is not decided. Of course, it will be remanded and fresh. Now that issue was raised by the first appellate court. It was not raised by the wife or so. On this point, and this section was referred in the impugned judgment also, paragraph 12, 7, 8, and 9. And they are saying, well, paragraph 12 of the impugned judgment, and page is final page 12. Family court is established for an area as per section 378 Family Court Act, and if no family court is established, then it would be the district court. Why it is referred, my lord? Because 7 it is said whatever the suit is pending before the district court after establishment of family court, it will be referred to the family court. That is why, my lord, it is district court. This is my submission. Civil just junior division has no. District just the civil court is also civil court, and if it is power is delegated to the any civil judge, it can also.
Now he raised the issue another. As per
it is deep.
Sakari, yes, it is merely a declaratory issue. Now, as per him, the 3 talak has already been given. There is a talak Hassan is already been completed.
Yes, this prayer
So
is
now his prayer is that it is merely a declaration. But your submission is a declaration for what? Declaration for divorce.
Yes,
For talak.
declaration for talak. Ultimately same. Ultimately same. Here prayer is not for declaring the dissolution of marriage in suit. And if they are saying that this talak is already, my lord, complete, then why, my lord, they have filed this? Why declaration is required under the Muslim law? Not required at all.
Yes, that is one big question. Why you have come?
Yeah.
If suppose as per you Talak-e Hasan is completed, is that their talak is there, a valid talak say.
Valid talak.
In 3 consecutive most probably occasion, the notices was given, and in spite of receiving, as you have submitted, in spite of receiving the notices, she did not return to her matrimonial house. So talak is already there. So why do you need a declaration now?
Well deployed. Why it is very so I think a second marriage for both the parties, there may sometimes require to as a proof of a court decree in produce the department here. Since they are employees, so for their service, it is required a court decree to be submitted here. Otherwise, if they are a general public, that may not be required for going to the court for a getting the decree of court. Because the employees, they have to bring a decree for their.
This is not a pleading of.
Pardon?
This is not a pleading of the case. In title, so it is not the pleading the government submit the requirement of any declaration. It's the pleaded case of the thing. And why where cause of action arose? That is the
No, as per your appellate authority, where passing the order was, there was a observation that you are at liberty to approach the appropriate forum.
Yes.
If you need the decree of divorce, that was the observation of the appellate forum. In the appellate court order, there's an observation that you can approach the proper forum.
Proper from that as per judgment, it appears that as per the appellate court held, is the district judge.
Yes, that is
district judge. But the
so there was a way to approach the district judge.
Yes.
I mean, you were given that liberty, but in a sense, if the order was passed, so it is your option. You could have approached the district judge.
But the observation of law is if the civil code has a jurisdiction. When the civil code is a the original civil code, munsif is the for finding a letter is so.
Yes, declaration should be always by munsif. Munsif or civil judge. It is not disputed.
Yeah, yes.
But by that declaration, you are seeking a divorce, isn't it?
Resolution of
that is.
But there is no barrier. As far slide up. There is no bar that should be to the district judge. It is meant to be a civil code. That means it does not mean that the criminal dispute should be filed before the district.
No, what your family code says. Family code as per the family code.
Yes.
Act.
Yes, family code. Where there is a family code is there, then a suit for proceeding between the parties of a marriage for a decree of nullity of marriage to be null and void, or as the case may be, nulling the marriage for restitution of conjugal rights, or judicial separation, or resolution of marriage. For A. Number B, a suit for proceeding for a declaration of the validity of a marriage, or as to the matrimonial status of a person. A suit for proceeding between the parties to a marriage with respect to property of the parties or of either of them. A suit for proceeding for an order of injunction of marriage, or a suit for proceeding for proceeding a suit for proceeding for there is logic that a declaratory suit.
Which order your section we are reading?
In this section there is a mentioned resolution of marriage.
Which section you are reading?
Section 7A. 7A. And the decisions I have relied a lot in, it is not mentioning that it should be a district judge. It is mentioned civil court has a jurisdiction. Both the judgment. may again read the Supreme Court judgment. It is nowhere mentioned that it should be the teacher's code. Paragraph 14 of the Supreme Court judgment. Paragraph number 14 may I read. Apex Court judgment. An elite question that arises is as to whether foods of the present kind would be barred under any provision of law. The learned counsel for the respondent has brought to our
16.
The Lordship, I am reading
Supreme Court judgment.
1-4 of the Apex Court judgment.
1-4.
Apex Court, Kumar Roy. Kumar Roy. That case was that the husband had filed a declaratory suit for declaration that the opposite party is not his legally married wife. That was the suit for declaration. And the paragraph 14, an elite question that arises to whether the suit of the present kind would be barred under any provision of law. The learned counsel for the respondent brought to our notice 2008. 2008 already object to the other provisions of the Act, the court shall have and exercise all the jurisdiction available by any district court or any subordinate civil court under any law for the time being in court in respect of suits or proceedings of the nature referred to in explanation. Claims on the suit and proceedings referred to in this section are suit proceedings of the following nature, namely, a suit or proceedings between the parties of a marriage for a decree of validity of marriage, declaring the marriage to be valid for annulling the marriage or the restitution of conjugal rights or dissolution of marriage. Exclusion of jurisdiction, where a family court is established for any area, no district court or subordinate civil court, referred to in 1 in relation to the such area as any jurisdiction of the suit or proceeding of the nature referred to in the subsection. Now, paragraph number 15 of this. It is obvious that a suit or proceeding between parties to a marriage for a decree of nullity or restitution of conjugal rights or judicial separation or dissolution of marriage all have reference to suits or petitions that are filed under the Hindu Marriage Act and or special marriage. And for the aforesaid list, there is no reference. This is important. There is no reference whatsoever, no suit that are filed for declaration of a legal character under section 34 of the Specific Relief Act. There is a case of declaration that the wife is already divorced. The opposite party, the respondent, has a divorced wife. That is the declaratory suit of the appellant here in the Lordship. Indeed, in a legal character, indeed in so and so Dulabai versus MP, this court had occasion to consider whether the civil court's jurisdiction was expressly or impliedly barred by statute. After referring to a number of judgments, this court laid down 7 propositions of law, of which 2 are relevant to the present. Whether there is an express bar of the jurisdiction of the court and examination of the scheme of the particular act to find the adequacy or the sufficiency of the remedies provided may be relevant, but is not decisive to sustain the jurisdiction of the civil. Where there is no express exclusion, the examination of the remedies and the scheme of the particular act to find out the intendment becomes necessary, and the result of the inquiry may be decisive. In the later case, it is necessary to see if the statute takes a special right or a liability and provide for the determination of the right or liability, then further lays down that all questions about the said right and liability shall be determined by the tribunal so constituted, and whether remedy is normally associated with actions in civil code prescribed by the state statute or not. An exclusion of the jurisdiction of the civil code is not readily to be inferred unless the conditions are above set down. On the reading of the aforesaid proposition, it is clear that the examination of the remedies provided in the scheme of Hindu Marriage Act and the Special Marriage Act show that the statute creates special rights for liabilities and provides for determination of rights relating to marriage. The Act do not lay down that all questions relating to the state rights and liabilities shall be determined only by the tribunal, which are constituted under the said Act. Section 8A of the Family Code Act excludes the civil court jurisdiction in respect of a suit or proceeding which is between the parties and filed under the Hindu Marriage Act and the Special Marriage. This is important. Family Code excludes the civil court jurisdiction in respect of a suit or proceeding which is between the parties and filed under the Hindu Marriage Act or Special Marriage Act. Here is the under Muslim law is not included. The Apex Code, specifically Hindu Marriage Act, Special Marriage Act is mentioned for the family code. So what the under Muslim law, where because in the Muslim law there is a provision under the Muslim law, your lordship, there is a already provision for divorce. So for since there is already provision for divorce, where the suit is annulled or dissolve a marriage or is for restitution of conjugal rights or judicial separation, it does not purport to bar the jurisdiction of the civil court. If a suit is filed under for declaration as the legal character of the alleged marriage. So here the that is a declaratory suit, Lord, only to declare that the it is a validly the divorce pronounced by the husband is valid as per law, as per Muslim. So it is clarified by the Apex Court that last type of suit there is no bar, and my friend's admission that the civil court should have been interpreted as the district judge court. But that is not the finding of the Apex Court and the Honorable Court. The civil court will only mean the district judge court. And if it is that in the absence of the family court, it should be the district. If in a particular area the family court is absent, then it should be. But that is not supported by any provisions of law or any authority. Where is the authority? There is no authority that in absence of the family court, it should only, the civil court means only the district judge court, not the municipal, not the civil judge.
Mr. MJ. Done it. It's an appeal under section 100 CPC against the judgment and decree dated 25/06/2025 passed by Learned Civil Judge Senior Division Alakandi, entitled appeal number 09, whereby the judgment and decree passed by Learned Civil Judge Junior Division Alakandi in matrimonial deed number 18/2024 6. This court had three following substantial question of at the time of admission in performance whether the learned lower appellate court has rightly set aside judgment and decree passed by learned civil judge Secretary Junior Division of Hailakandi in matrimonial Secretary number 18 of 2024 on the ground of jurisdiction in absence of jurisdictional family. It is submitted that the present appellant has appointed had instituted a matrimonial secretary suit before the learned civil judge junior division Hailakandi, which was registered as matrimonial deed suit number 18 of 2024. Hereby is prayed for declaration of dissolution of marriage dated 25/07/2021 in form of talak, along with a decree for confirmation of written divorce executed and given by the appellant on 12/11/2023, 17/12/2023 and 30/01/2024 to the respondent. Along with some other other declaratory along with further declaratory relief that the marriage between the appellant and the respondent is dissolved. Dissolved. Next one. During the no. Next paragraph. It was submitted that during the pendency of the said suit, the present appellant had adduced 5 prosecution witnesses, including the appellant, and exhibited some documents. After considering the evidence on record as well as the document, learned civil judge junior division Hailakandi had passed the judgment and decree dated 15/5/2025 with the following reports. Number 1, that the marriage between the parties stands dissolved in the form of number 2, that written divorce talak executed by the appellant is hereby done. There in the suit, they have not appeared. WS?
No.
No WS filed. But notice was served. In the judgment it is mentioned. Civil junior division cases judgment is at page
number 21.
21.
Paragraph number 26. Page number 26, paragraph number 3. Page number 24, paragraph number 4. Page number 24, paragraph 4. But he failed to submit written statement. The suit therefore proceeded against the defendant.
The party submitted the summons were duly served on the defendant, but she failed to appear for the learned track below, and the case proceeded. Next paragraph. Mr. Kadir further submitted that the learned Court of Civil Justice Junior Division had discussed in detail, made detailed discussion in the following issues. The following issues. Whether the marriage between the plaintiff and the defendant is dissolved upon by a talaq by the plaintiff. Number two, whether the plaintiff is entitled decree as written. Thereafter, considering the documents exhibited by the appellant, wherein it has also been shown that he issued 3 consecutive notices to the defendant public respondent. Despite of receiving those notices, she never returned to her matrimonial house, and accordingly, the which is and as per the requirement of Talaq Hassan, the interval of period of 1 month, 3 notices is to be issued, and accordingly, it is the observation of the learned civil judge junior division that those notices were duly served, which were also exhibited by the appellant, and accordingly, the Talaq Hassan. It becomes Talaq Hassan, and thus the divorce was already completed. Your divorce was completed on which date? As per you, Talaq 3 dates na you given 12/11/23, 17/11/23, and 31/24. After the said
Page number 24.
thereafter the learned civil justice junior division had passed the decree declaring that the marriage between the parties stands dissolved in the form of talaq, and the written divorce of the talaq executed by the plaintiff was also confirmed. Mr. Kadir further submitted that it is of a case of seeking any divorce before the Rane Munshi Junior Division, but it was a case seeking declaration that the talaq which was given by the plaintiff written form is valid, and the wife can be considered as a divorced wife of the present appellant. Thus, he submitted that there cannot be any bar to entertain such nature of application, such nature of title suit, such nature of declaratory suit by civil judge junior division, and the decree passed by the learned trial court below is also a valid decree. Next. Mr. Kadir Patel submitted that on the respondent defendant had approached, thereafter the respondent defendant had approached the Court of Learned Civil Judge, Senior Division, Hailakandi, Senior Division, Hailakandi, against the judgment and decree passed by the Learned Civil Judge, Junior Division, dated 15/5/2025 and 22/5/2025. But Mr. Kadir Patel stated that the Learned Civil Judge, Junior Division had rightly entertained the said said declaratory suit in absence of you're saying again family court. Now see here you cannot take two stand. In one stand you are saying that it is merely a declaratory suit. You are saying it is merely a declaratory suit. So you are not seeking any divorce by that said declaratory suit. Simple a declaration that the talak-e-Hasan or talak which was given by the plaintiff is a valid talak. That is the only declaration, and as well as he or she is the divorced wife of so and so. So at that time you cannot take the stand of but the approach is so and so. No, the Learned oh no, अच्छा, itu kan. Oh no, oh. Declaratory suit in absence he Learned it's sentence. But the preferred and availability to agree to the preferred and availability to which is registered as Patent Appeal number 09 of 25. But the Learned Civil Judge Senior Division had framed and the Learned Appellate Court had framed three issues for determination, but without discussing on the other merits of the case, had dismissed the had allowed the appeal only considering only with the view that the Learned Court of Junior Civil Judge Junior Division is lack of jurisdictional has no jurisdiction to entertain such nature of case and declare the decree and as a result the appellate court had declared the decree passed by the learned Munshi as nullity. And there is no further discussion was made on the merit of the other merits of the case. On being agreed to the judgment and order passed by the learned civil judge senior division in title appeal number so and so, the present second appeal has been preferred. Second appeal under section 100 CPC has been preferred by the present. Next, Mr. Kadir further submitted that the petition, the learned appellate court had misconceived with the law and as it was and failed to appreciate the fact that the plaintiff public appellant had approached the learned civil judge junior division only with a prayer for declaration that the talak given by the plaintiff is a valid talak, as well as where is the prayer? Prayer was there? Prayer? Please, 47. Praying. No, he declares. Only praying for it. And appreciate it. As well as with a further declaration that written divorce of the talak executed by the plaintiff on 12/11/2023, 17/12/2023, and 30/01/2023 can be considered as a final. It further submitted that as per the Family Courts Act, the district judge court as well as the other and the other subordinate courts are barred in entertaining the matrimonial disputes, which include where is the explanation? wherefrom you are saying that it is for only for Hindu marriage? Explanation which part was there? It was for Hindu marriage and the judgment. The marriage for degree, which includes marriage for degree of nullity, comma, restitution of conjugal rights, uh, judicial separation, or dissolution of marriage, or any other oblique petitions that are filed under the Hindu Marriage Act and oblique or Special Marriage Act. Special Marriage Act. But here in the instant case, it is a case where the petitioner, appellant had only prayed for a declaration that the talaq which was given by the plaintiff on 3 subsequent dates to written form was a valid talaq, and which was accordingly decreed by the learned civil judge junior division. So, question of entertaining the such kind of petition by the family court, or in absence of family court by the district judge, court of district judge, does not arise at all, as the court of Munship or civil judge junior division has every authority and power to pass such kind of decree as per section, such kind of entertain such kind of declaratory suit. In support of his submission, he also relied on a decision of Honorable Supreme Court, a report passed in case of Samar Kumar Roy, Supra, reported in 2017, 9 SCC 591, and basically emphasized on para 15 and 16 of the state judgment, which readed. In that context, he also placed reliance on the coordinate order, the judgment of the coordinate bench of this court, passed in RSA number 49 of 2024, and emphasized on para 14 of the state. Next one, Mr. Hawk, the learned counsel appearing for the response submitted that the learned appellate court had rightly passed the order as the civil judge junior division has no jurisdictional authority to pass such kind of declaration. Mr. Hawk further submitted that though it is stated to be a declaratory suit, but by the said said suit of the petitioner, the appellant is seeking for a decree of divorce, which cannot be entertained or passed by a court of learned civil judge. Mr. Hawk accordingly submitted that the learned appellate court had rightly discussed the point of jurisdiction, and accordingly it is held that the decree which is passed by the learned Munship is a nullity as he does not possess any jurisdictional authority to pass such kind of declaration whereby the the, the uh, prayer for declaration of divorce is granted by the learned court. Mr. Hawkwater submitted that it is the family court which such nature of matrimonial suits or petitions can be decided, and in absence of the family court, the district judge has the authority of the power to entertain such kind of matrimonial suit public application. We further submitted that as per Section 8 of the Family Courts Act, the jurisdiction of district judges or the other subordinate courts is part in presence of family court, and where the family court is in absence, it is only the district judge wherein such kind of matrimonial suits, public proceeding, seeking divorce or dissolution of marriage, etc., can be entertained by the court. Next paragraph. He further submitted that the learned appellate court rightly they had also granted the liberty to the appellant to approach the proper forum seeking seeking the degree of divorce through talaq, and without and in instead of approaching the appropriate forum, the appellant had approached this court with a petition under Section 100 of CPC, which cannot be which is not maintainable and is private dismissed. Mr. Cock accordingly submitted that there is no reason to make any interference in the judgment and order passed by the learned appellate court in title appeal number so and so. Okay, we'll refer you. No. I'll try to dispose of the matter because 1, 2, 3 pages remain. Unless your submission, I have already.
He has to submit it before the court, that is before the civil court meeting. And within 30 days of the knowledge of the parties may object to that award for setting aside. And the period of that objection is 30 days.
30 days limitation.
They did not come. We went. They did not file any objection, my lord, within 30 days. So we filed an application for pronouncing judgment in terms of the award.
Before the arbitrator.
Before the court.
Okay, court.
Before the
yes.
Court. Pronounce judgment in terms of argument. The lower court has not allowed my petition. So I came before this honorable court. That was dismissed. Thereafter, I went to this honorable Supreme Court. Supreme Court allowed. Supreme Court said that yes, their 30 days time has already expired. Now, after decision of the honorable Supreme Court, I filed an application for pronouncement of judgment and preparation of decree in terms of the award. They filed an application for condonation of delay. They filed a petition for condonation of delay because honorable Supreme Court has said that 30 days time was already over. So that petition was rejected. Subsequently, the petition filed by earlier raising objection, that was also rejected, Milan. So against the order of main petition they have come, they have not challenged the order of condonation petition, my lord, whatever, my lord. After filing of the appeal, the entire appeal was heard, and in fact, it was taken for disposal, my lord. And after 3 months or so, my lord, this case was listed, and the Honorable Court has said that the condonation petition is required to be examined, and therefore the appeal was admitted. And Milord, stay was not granted because of those submissions and reasoning given in the order itself. Now the case is for final disposal, my lord, and they have not brought the.
No, but why for final disposal? You have filed your this condonation.
I'm going to file by the petition and litigation to bring the petition, copy of the petition of the condonation. Immediately after my lord.
But though the appeal is admitted, the condonation is still open. It's not decided now.
No, my lord. Condonation has already been decided. The condonation petition filed before the lower court, not before this honorable court.
You have to brought through an additional appeal.
Yes.
But why at this stage, after admission of the appeal, why scrutinization of those condemnation petition is required now? Is there
That
any?
is the observation of the court.
What I'm on?
Because my lord, the Lanet Trial Court has also made an observation that they cannot made out any case of.
Acha, okay. Now whatever, yes, I can understand. But you were there with a prayer for condonation.
Yes.
That was rejected or whatever.
Yes.
But now, even after rejection of the order, both the matters you have come before this court for as a whole appeal and the condonation also.
Yes.
But at the time of filing, passing the order by the court and bench of this court, the matter of condonation was not before the court.
Not matter of the petition of the
Condonation was not before the court. Okay, then it was not before the court. Now the question is that in spite of that, the appeal is admitted.
Yes.
So now why again it is required? I just I'm
Madam.
my confusion.
Otherwise, my lord, issue was.
My lord, since it has already been admitted, my lord, LCR may be called for that. Then whole petition and everything will come.
No, but one court and bench of this court had passed the order in that case. So I should not interfere. In that case, we may call for the scan copy.
Copy. That can be.
Why only the scan copy? It has already been disposed of matter, I think.
No, my lord, execution is going on.
No, execution is going on.
Execution.
Arbitration has already been.
That may be installed. That is why, my lord.
In that case, we have to call for the scan copy.
Scan copy, my lord. That can be.
Oh. Confusing matter.
Yes.
Third, Ms. A. Gayan. You are appearing on behalf of as a strength of CGC as CGC for the appellate and also as substitute counsel for the respondent. It is submitted by Ms. Gayan that the appeal has already been admitted by its order dated 11/9/2025. However, the appellate was directed to produce the condonation petition which was filed before the Learned Trial Court below, However, she could not brought the said petition along with the additional affidavit. Accordingly, submitted that she requires some more time to file the additional affidavit, bringing the petition for condonation which was earlier prayer allowed. Further, considering the fact that appeal has already been admitted, call for the scan copy of the PCR. The matter be listed when it can be after 4 weeks, 3 weeks.
My lord, the date be fixed. Otherwise, my lord, in the paragraph 14 of the earlier order, it was, my lord, observed that this is a very long pending matter. So on 12th of February.
Proceeding is going on. Maybe date matter for time being matter.
That has already been rejected.
It's already been observed, so
But-
cannot be now.
Or execution.
You somehow
Yes. So matter before
try
matter,
to.
before that matter.
When it is fixed, your matter is.
Yes.
कब
I'm giving the date
वहाँ पे कब है वहाँ पे
Give us the date.
हाँ नीचे
वो appear
oh they
47 filed here.
Huh?
They have filed 47.
I'm giving the date.
47 চলি আছে দিয়ক আপোনাৰ চলি আছে my lord
7 already.
not
Yes, sir. 47. So
47
what to say? 47.
they have filed objection
Yeah, it's a big weapon, na.
28
47.
January matter.
Huh?
Date is fixed on 28 January. Execution procedure.
But we are not in a position to fix it on before that 28th January because
Week of February.
first week of February can be at best 12 and 12th of February. Yes,
on 12 will. On 12
okay, 12th. You have filed your objection.
No, no, it's fine. Okay, I think
It is listed for hearing only. You are for the appellant?
Appellant.
Appellant. Heard, Mr. You are made appearing none appears on call for the respondent. You want fixed date? We have fixed. If you fixed date, it's very problematic. Twelfth of February. Right. কিরকম দিতে? এটা